Continuing with Part 3, Motions Hearing, January 19, 2007. The Court. No, but let me rephrase my question. If the state's position is that the defendant wants to offer evidence that a third party or parties might be responsible for the crime, that the only way that they can do that is if they provide the motive plus opportunity plus a direct connection to the crime, or is the state's position that, well, there's still this legitimate tendency test, but they have to, if they are not going to use motive, they have to show opportunity and a direct connection? Attorney Fallon, under Denny, they have to establish all three. Now, I want to address, if I may, because I think that this dovetails into the point you were making. The Court. Okay. Attorney Fallon, you request if Denny doesn't apply, then what do we apply? I think counsel is correct. 904.01, 0.02, and 0.03 analysis is the analysis that would be the fallback position to determine the admissibility of this evidence. Then I would invite the court to look at the evidence under that analytical framework as well, because quite frankly, it's inadmissible under that framework, and here's why. Relevance, as I mentioned earlier, has two facets. First is whether the evidence relates to a fact or proposition that is of consequence and why that may be met here. The second consideration for relevance is that we all learned in law school years ago as the materiality component of our relevant statute, and that is whether the other act evidence or just other acts, whether the evidence has a tendency to make a consequential fact more probable or less probable. The fact that, for instance, Robert Fabian was on a rabbit hunt with a .22, the fact that there was a golf cart, that was found rather interesting by one of the cadaver dogs. The fact that there was smoke in the middle of the salvage yard as opposed to the far corner up on the upper right side, great. But how does that really make a consequence here? The consequences of fact more or less probable. And even if you were to accept the establishment of the second facet of relevance, you must still then evaluate whether the probability or probity, the strength, and this is where the counsel misreads Holmes, and I think the court happily noted, where you do consider the strength of what's being discussed here. So is the probative value substantially outweighed by the prejudicial effect, by the confusion of issues, the potential of the jury being misled under time considerations, and things of that sort? And even if a 904.03 balancing test, every one of those individuals mentioned in the statement on third-party liability fails to meet the standard, that standard, admittedly a lower standard of admissibility as well, because I strongly challenge whether they meet the second facet of relevance, the old materiality. And even if they did, the probative value under all of the evidence known here is substantially outweighed by the prejudicial effect. Thank you. The court. All right. Let's take a lunch break, and then we'll come back and I will hear argument on the other issues. I'm in my office for lunch, so I will defer to counsel. How much time do you want? Attorney Strang, 45 minutes to an hour. The court, 1:15. Does that work? Attorney Fallon, sure. The court, see you at 1:15. Noon recess taken. The court, at this time, we're back on the record. All counsel and defendant are present in the courtroom. When we left off before lunch, the court finished hearing argument on third-party evidence issue. That is the Denny motion. Counsel, I'm not sure whether next it pays to take up the wrongful conviction issue or plaintiff blood issue first. Attorney Fallon, we would prefer to take up the blood vial issue, the plaintiff blood issue. The court, any objection from the defense? Attorney Buting, no. The court, very well. I will hear from the defense first then. Who will be presenting the matter? Mr. Buting? Attorney Beating, yes. The court. Very well, you may proceed. Attorney Beating, like Mr. Strang said, we have a pretty thoroughly set this forth in written submission, so I don't want to repeat everything in there, but I do want to point out a few things. First, the Richardson case. I think we need to recognize and distinguish it a little bit from what we have here. And I understand, I think why the case was decided the way it was. There's a very big difference between that case and this. That was a direct evidence case. There was a victim or alleged victim at the time saying Mr. Richardson had sex with me or raped me. He denied it, but balance, and offered a convoluted argument of a frame-up that was collateral, and in part because it was 2 steps removed from the victim. Wasn't just the victim, wasn't just the victim's mother. It was his ex-wife who supposedly then got the victim's mother and the victim to frame him. What the court noted as frame-up evidence when it came to the question of probative value, how it had little probative value, they bounced it against the fact that he says, I didn't have sex with her, period. Yet his semen was there. Her underclothes was found there. The injuries, significant injuries, torn hymen and whatnot, which his frame-up evidence did not go to explain any of. Wasn't like he was saying she, deliberately injured herself, tore her hymen, did all this kind of stuff. His frame-up evidence did not go to explain away any of that evidence. Now, this case, on the other hand, is a circumstantial case. There is no direct evidence that Mr. Avery committed this crime. Here, the proffered evidence does offer an explanation for some of the circumstantial evidence directly. And I can just hear it right now. If this blood evidence is not allowed in, the prosecution is going to get up in their closing argument, and they're going to say, no matter what doubt the defense may have raised about this or that or these other pieces of evidence, the bottom line is his blood was in her car, and that kills him. He said he was never in her car. His blood was in her car. We will be standing there with our hands completely tied behind our back, unable to defend against the underlying accusation in this case without this evidence. That's why, in this case, it goes directly to the heart of the right to present, the constitutional right to present a defense. If this is, frankly, if we're not allowed to do this, I think this case is going to be reversed, because there is no other way that Mr. Avery can adequately defend himself against these allegations that he made from the very beginning of this case. I think even before he was arrested, or certainly must have been before he was arrested, because he was saying it to the television cameras. If my blood is in her car, or my DNA is in her car, it was planted because I didn't go in that car. That's the first point I want to make. Second point, I want to clear up something here, because the state wants to merge Denny and Richardson in this case because of the blood planting defense. That's partly because I think they wrongly assume that if the police planted the blood, necessarily they also murdered Teresa Halbach. And that does not follow logically, and it does not necessarily follow with the defense that can be offered. Mr. Avery never said that. He is entitled to let the jury consider that some other unknown individual may have committed this murder, and that the police are opportunistic and took the opportunity that was presented to frame him, which thereby totally destroyed his civil claim against them. That's why, for instance, it's entirely unnecessary, therefore, for us to show that one or more police officers had a motive to kill Teresa Halbach, because they are separate. What the pleadings demonstrate is a motive to frame Mr. Avery, and an opportunity to do it as well. So when they talk about recognized, by the way, not being a civil case, we don't have the opportunity to do depositions, to question all these officers ahead of time, and present perhaps as clear and thorough and airtight an offer of proof as you would like in a civil case. These are police officers that, if they were involved necessarily, have covered their tracks in a way that we have not been able to pierce yet. Some more of that may come out at trial and should come out at trial. But at this point, we're limited by the fact that how this defendant was going to ever prove a direct connection, saying that a witness saw Lieutenant Lenk or Sergeant Colborn or anyone else take that vial of blood and put it. It's almost impossible to expect in any case a defendant being able to do that. The police control the scene, they control the evidence, they control the documentation of that evidence, the written documents. Despite all that, I think we have already shown they slipped up and that there are indications that a reasonable jury has a right to hear and look at and consider when we're talking about whether or not there's a reasonable doubt that Mr. Avery committed this offense. And logically, if he says there's no way his blood could be in there in that car because he was never in that car, and his blood is found there, if evidence shows that there's an explanation that someone else put it there, then that would also tend to indicate at least a reasonable doubt about whether he committed the crime itself, because it pulls the rug out from underneath one of the major pillars of the state's case and challenges the credibility and the reliability of everything else that they have brought up, and to try and point the finger against Mr. Stephen Avery. The one thing that I want to say, though, about Holmes, South Carolina versus Holmes, it's not that we're saying that Holmes overrules Denny or that Holmes even overrules Richardson. But there is a one aspect of Richardson, though, that may no longer survive, and that is the whole the idea that you weigh the strength of the state's case against the proffered evidence from the defense. And in that case, that's why I'm saying that case, by the way, has never been cited, as far as I could tell, by any other case authority in the country since it was decided. And I think it's because it's a narrow case on these narrow facts. But the analysis that they went through and that I went through earlier here about how, he says he was framed by this girl, not by the girl or her mother, but by his ex-wife, putting them all up to it. They didn't balance that say, well, let's look at that. But besides the fact that there's semen, there's her bedclothes, there's the injuries, and ultimately they said the analysis, as I see it, is that they said that outweighed the defense. That's why I think Holmes says you cannot do. Holmes says you have to look at the proffered defense evidence separate from the state's evidence. At page 10, at the slip opinion, this is really the second to the last or the third to the last paragraph of the whole decision. What they point out is, quote, just because the prosecution evidence, if credited, would provide strong support for a guilty verdict, it does not follow that the evidence of a third-party guilt has only a weak logical connection to the central issue in the case. And where the credibility of the prosecution's witness or the reliability of the evidence is not conceded, the strength of the prosecution's case cannot be assessed without making the sort of factual findings that have been traditionally been reserved for the trier of fact, and that South Carolina did not purport to make in this case. I think we may fall into a similar trap here if we start trying to balance too much what the state's forensic evidence is versus Mr. Avery's in this case. But let me turn to some of the so-called facts that the state has now presented in their response. These facts, a number of them are disputed, and therefore the fact finder is disputed facts should be the jury, not the court, because they go directly to Mr. Avery's right, to the heart of his right to present a defense. For instance, paragraph 5, page 2 of the state's response says that Lenk placed himself on duty at approximately noon, and at approximately 2 p.m. he arrived on scene. Well, right away, that's directly contradicted by the sworn testimony from Lieutenant Lenk that he arrived at the property at 6:30 or 7 o'clock. Lenk never filed a report of his activities or whereabouts. They have, as yet, produced no work records of his. We did receive, however, some, and by the way, some of the documents that we have asked for in the Brady motion should not be implied to mean that there isn't already significant evidence that supports the arguments we're making. We want to make sure there is nothing else out there that would make it even stronger. But we do have reports that Deputy Inspector Shetter made showing the hours that every officer worked on that day and what their duties were. And that's what we put in our proffer here. Lenk says he worked 10 hours. We have also have logs that show when officers signed in and signed out. And that goes to paragraph number 6 in Mr. Fallon's response, that a logbook is created to account for the comings and goings of law officers and others. Well, I would add, except for Mr. Lenk, because according to the logbook, he never arrived at the scene of the Avery salvage, and yet he was there because they do show that he left. A reasonable inference that a jury, and only a jury, should make is that somehow snuck in unnoticed. He was able to bypass that. And if he was able to bypass that perimeter or whatever it was, then what else could have been able to bypass without being documentation? That doesn't necessarily require a huge conspiracy of the entire police department. He may have, the person who's the guard, who's checking people in and logs, may or may not have been involved in this at all. If he was able to bypass that guard, he may well have been able to get to the vehicle. These are factual contradictions. They are not pure speculation, as Mr. Fallon would argue. He was there, but he never checked in. He said he worked 10 hours, but the only record of his work is according to his testimony, 4 hours at most. 6:30 to 7 is when he arrived. I think he said under oath, and he left at 10:40. Now, the state is perfectly free to explain to the jury, if they can, these factual contradictions away. Mr. Avery is equally free to argue that these factual contradictions to the jury in the way that he sees fit, and that they fit and support his theory of defense. Another fact, so-called fact, mentioned, I believe, in paragraph 14, is that the DNA profile obtained from the key to the SUV was not blood, but another biological source. Well, actually, I don't believe that's been ruled out according to the preliminary hearing testimony, because there was never a presumptive test done on the key. Visually, she did see it, but she swabbed it and immediately for DNA. If all the blood could be seen visually, there would be no reason for doing a presumptive test. So we don't know whether the source of his DNA at that point on the key could have been from blood or not. More importantly, the blood is found in his house, where they had 4 days to obtain plenty of sources of his own DNA. It is not unusual to find someone's DNA in their house. It's all over the place. And on top of that, they have specific DNA samples from him, but buccal swabs in not just the clerk's office, but in the Manitowoc County Sheriff's Department from prior DNA exoneration efforts. And that was verified by their own investigation. Paragraph 14 in so-called facts claims that this Marlene Crancewood testified that she's a phlebotomist and that she drew the blood sample and that she was the one that put the hole in the tube top. Well, we have seen no such report. And his response earlier was, we don't have to show all of our cards. This is like the nature of a rebuttal witness, is what I'm assuming he got the report. We have seen the interviews of everybody else in the links of these, no pun intended, of this chain, but there's no report of this nurse. Now, he may say they don't have to show all of their cards, but that's exactly what they're trying to do to get the defense to do, number one. And number two, he can't put these facts in here and make avertments to the court that they are facts if he is not going to turn over any reports that support it to the defense. And we have seen nothing of that. More importantly, the tube top was not sealed. And we said that right in our papers, our moving papers, that the hole there is only one of several ways the blood could have been taken. Whether the hole was put there or used, an existing hole was used by inserting a needle to withdraw it, or even more likely that the top was just pulled right off and blood, whatever they needed, is taken out. Because it was an unsecured, there really would not even have been a need to use a needle. You just pull the top right off. Paragraph 17, and this is an example of how all these so-called facts are jury questions that only a jury can decide. Moreover, testimony would reveal that neither Lenk nor Sergeant Colborn or anyone else associated with the wrongful conviction of the lawsuit entered the SUV on Saturday, November 5th. Oh, okay, so that's it. That's the end of the question, huh? We're just supposed to accept that and walk away and go home and say, Lenk is now saying that. That's all we need. Please, that is for a jury to decide. Lenk's credibility is already in question because he's been caught in inconsistencies under oath at best, perjury at best for the defense perspective. And the same that goes for the claim later that Lenk did no more than just prepare transmittal paperwork. Again, that's what we're supposed to believe and just accept as a given fact instead of letting the jury know. In essence, what they want us to do is just assume that it's a mere coincidence that the Lenk is on these documents in 2002, that he's a deposed witness in a civil case 3 weeks earlier, that he volunteers to search the defendant's home after his superiors have already determined that there is a conflict of interest, and with his department's involvement because of the very same lawsuit. He doesn't tell, neither does Colborn, the new superior officers, that he was a witness involved in that case. He finds this magic key in plain view when no one else could, and he's still involved in the case 5 months later, in March, after Brendan Dassey's so-called confession when the bullet was found. Now, we don't know, and I don't want to leave the court with the impression that the only explanation is that Mr. Lenk planted that bullet there. We don't know that. There are other explanations, including one that it wasn't even her DNA on that bullet, because the evidence will also show that the DNA analysis of that bullet was flawed in that control failed and included the analyst's own DNA, which by protocol means the test gets thrown out. But she applied for a deviation from that protocol in order to make the call. And the evidence will also show that this is the only time in her career that she's ever even asked to deviate from a protocol. Again, those are questions that a jury is going to have to decide, and the jury will hear. So really, what it comes down to is, it seems to me, the state is arguing that they are conceding that it's material and it's relevant and that it's probative, but they really, what it comes down to, that this is a waste of time. This is this is confusion. There's unfair prejudice. The unfair prejudice thing, let me just respond briefly to, since we are in closed hearing, we can talk about these inmate statements. They claim, well, the court has already ruled these inmate statements to be inadmissible and that somehow they are prejudiced by that. When in fact, if they think that it is so critical to their case that those statements are so important, they have an appeal as of right that they could have taken or still could under 974.05, State versus Eichmann, which says that an order that bars admission of evidence that, quote, might normally be determinative to the success of the prosecution gives them an automatic right to an appeal, and they haven't done that. And the case also says that they give the state so much authority and discretion that they are the prosecution is the one to make the determination of whether evidence that is excluded is that important to them or not. So to argue that this is somehow prejudice them so much when they have other remedies is really an auspicious argument. So it comes down to the confusion and delay, which is the last argument that they make, which is really a 904.03 argument. And they argue that so much time that is going to be taken up by the defense Well, we just saw a calendar here that shows, I don't remember how many days for the state's case, but basically 4 weeks, but only, I'm sorry, with 5 days projected for the defense. As if any evidence that goes that would tend to indicate Mr. Avery is not guilty is somehow a waste of time. That's absurd. They claim there would be an endless parade of witnesses. Well, and that would be forced to present an hour by hour accounting for Lieutenant Lenk and Colborn or whatever. First of all, the state, in particular, the Manitowoc County officers put themselves in that position. They chose to remain involved in this investigation when it's obvious to everybody else that they shouldn't be. Not only that day, but even 5 months later, when Lenk is at the scene again, still involved. It's a conflict of interest. It demonstrates their bias, and bias is not a collateral matter, particularly when it's this critical to the defense, and it's never a waste of time. I disagree that every witness they discuss in here has to testify, and that's going to take forever. At some point they may. We don't need them to offer if they feel like they need to, if they think that interviewing witness 15 months later when they could have done it right away, then relying on a 15-month-old memories is probative. So be it. It would be their choice to waste the jury's time, not ours. So for all those reasons, I think the defense has presented a very strong case of the importance, relevance, and indeed the necessity that this blood vial evidence be introduced or presented in this case. So we oppose the state's motion to exclude. If the court has questions about, again, feel free to just throw them at me here if there's some legal issues or questions. The court. What is the defense version of when the blood would have been taken from the clerk's office? Is it between Attorney Strang? It's not 2 years like the court, I think, at one point, or what Mr. Fallon argues something about from September 2003. We're not going to be offering that as like somehow these officers took a sample of his blood 2 years earlier and just hung on to it until the opportunity. I can't completely rule that out, but I think the most likely scenario is going to be that it was after Teresa Halbach's disappearance, probably after Teresa Halbach's disappearance was reported, which narrows it even more. But again, the court. So sometime between 10/31 and November, is it the 5th? Attorney Buting, yes, November 5th. Attorney Fallon, actually, she's reported missing on the 3rd. The court, okay. Attorney Fallon, but last seen on the 31st. The court, okay. So November 3rd and November 5th. And I think there was, and this may have been touched on this morning, the idea who had committed this crime and whether or not anyone from the Manitowoc County Sheriff's Department would have been committed or would have been involved in the commission of this homicide. That is not part of the state's or the defense theory, or I don't want to put words in your mouth. What is the theory? Attorney Buting, I think that if we're going to argue that, well, probably the only ones that would fit that scenario would be Lenk and Colborn, because we think there's a motive. At least there's bias. If there's strong enough motive to also involve killing, this is not going to be a primary defense that's offered. I think that I can't rule out that a jury could consider it, but they had opportunity because, well, we don't know if they had opportunity. We haven't determined that exactly what they were doing on the 31st. That may be ruled out by simply by producing the documents that we requested back in December 15th, I believe. They may have alibis for the actual crime itself, so that might not even be an issue the jury could even speculate on. It's more likely, and frankly, that these are independent events. The court, all right. I mean, to leave open the possibility that it would be alleged that either Lenk or Colborn were involved. The argument would be that somehow, because they were employees of the Manitowoc County Sheriff's Department, and Manitowoc County Sheriff's Department was being sued by Mr. Avery for a claim that is, near as I understand it, was covered by insurance. I don't know what the limits of the policy might have been, but either that either Lenk or Colborn felt that they had a sufficient stake and that they would have been a motive for them to kill Teresa Halbach for the opportunity to frame Stephen Avery. Attorney Buting, probably not. Very, very likely not. And my only hesitation in saying that is because I just don't know what they did or where they were on October 31st, even though we asked for it for over a month ago. But unless we could show some connection, I mean, I think in the instance you would have to satisfy Denny, and we don't have a connection to them to the scene. But in any event, I think the motive is not a motive to kill. I think the motive is a motive to frame. And that's why the defense is coupled with not just planning of the blood theory defense, but also the investigative bias that ignored other likely suspects to the point to where we're getting preferential treatment in the case of Chuck Avery. But also the recognize that on November 5th, before the body has even been found, when all they have is a vehicle with some blood in it. In fact, at that point, they didn't even have that because nobody at the scene. That's another important thing. None of the cops who originally arrived on the scene saw any blood in it inside the RAV. It was broad daylight on a sunny, well, maybe not sunny, but broad daylight on Saturday morning, 11 a.m. They've got flashlights with them, and they are looking in the car as well. They are able to see little bits and paper and with her name on it. They're able to see all this stuff, and they don't see a piece, a splotch of blood right on the ignition where they were looking, shining around the whole dash area looking for VIN numbers. That's very questionable. But even without seeing all of that, when they go apply for a search warrant, they are swearing under oath that they think there is probable cause to believe evidence of a crime, including homicide, occurred. So for whatever reason, whether they were involved in it, or perhaps more likely, they know how these things turn out, they had enough at that point to realize that's where this was going in all likelihood. I think that's more likely the scenario, but the court. I indicated to counsel when we were talking about setting up this hearing today in terms of scheduling that one matter that concerned me was the question of whether bias evidence had to be related to a particular witness or whether or not there was some argument that bias could be imputed to an entire, in this case, Sheriff's Department. Anything from the defense on that issue? Attorney Buting. Mr. Strang is going to take that issue, Your Honor. Attorney Strang, only because I'm the one who took a look at that, Your Honor. And to me, the bottom line is that the evidence of bias adduced on cross-examination or conceivably extrinsic evidence of this case is related to an individual witness. You know, it's the witness bias that is relevant and important to a jury in assessing the witness credibility at trial. That said, one of the biases that we can have as human beings is, of course, an institutional bias. It's only one of the biases that may drive us, that may tilt our behavior, our words, in one way or another. Now, I didn't find anything anywhere that addressed specifically cross-examination of an individual witness on the question of institutional bias. But again, I wouldn't expect to find that because the issue is bias of the individual, which may have an institutional roots. And there I did find, some useful sort of comment by courts, not directly on point, but it helped me to think about the question of bias as it relates to an individual witness. When the U.S. Supreme Court has spoken of institutional bias, when it used that term, it's most often been in the context of a conviction at trial, a reversal on appeal, or a conviction after a guilty plea, then a reversal on appeal, a remand, and then the state upping the ante or the court upping the ante, either with an additional charge on retrial or with a longer sentence on retrial. And defendants then challenge that on the subsequent appeal versus as vindictive and a denial of due process. And I think that the very first time the U.S. Supreme Court spoke of institutional bias was in acknowledging that its decisions putting the process limits on higher sentences after remand or additional charges after remand. And here I'm quoting the U.S. Supreme Court, reflected recognition by the court of institutional bias inherent in the judicial system against the retrial of issues that already have been decided, close quote. And that's the United States versus Goodwin in 1982. The other common setting or other setting in which the Supreme Court has spoken of institutional bias is considering forced medication or competency assessments, competency to refuse medication, for example, and the court recognizing that often these are done by state mental hospitals or state institutions by psychologists or psychiatrists employed by the state with an interest in furthering treatment as the doctors think is recommended. And there could be an institutional bias that there may color the testimony of such witnesses in favor of forcing medication. So, what it says to me is, of course, and I started thinking about it, all of us, to the extent work for an institution or within an institution, may adopt its interest or as our own biases. This is why it is not at all uncommon or improper for the state to ask defense expert witnesses, how much are you being paid? Who is paying you? In other words, the old biblical comment in the Gospels, his bread I eat, his song I sing. Also fair with the defense, with the state witnesses to establish that they are employed by the same sovereign who's prosecuting a defendant. In a civil case, not all that uncommon or improper for one side's expert to be asked whether he or she had ever testified for the other side in a civil conflict. A toxic tort or an epidemiologist is called for an example, or whatever an example might be, a medical malpractice case in which a particular MD is simply known as a plaintiff's doctor or as a defense doctor. And again, that gets at the issue of institutional bias. We don't enshrine that as significant in of itself. It is just an aspect of the individual bias that one explores with any witness, or may be entitled to explore with any witness. So, in its application here, the state will call them. The state will call, or predict, at least in its case in chief, a number of Manitowoc County Sheriff's Department employees. Indeed, every significant piece of physical evidence in the case against Stephen Avery was discovered first by, or had present at the time of discovery, a Manitowoc County Sheriff's Department employee. So we're going to hear from those people, and will it be appropriate to cross-examine them, establish their employment, establish their awareness of the lawsuit against their department, establish that they take pride in their work, and that they take pride in the reputation of the department, and that they felt that pride imperiled by the allegations of their own department had embarked on a course of action that has led to a 32-year sentence for a man who didn't commit the crime of which he was convicted. Yes, that is appropriate because that officer who wears that uniform is entitled to take pride in his work, in his uniform, in his department, and is entitled, I guess, in a sense, he's human, to have his actions, words, thoughts affected subtly, perhaps even subconsciously, by his own human biases. We all have these, and that's why it's so important for bias to be explored. It's not a dirty word in the end, but it is essential for the neutral fact finders in weighing sometimes difficult nuances of credibility. Now, as to some of the Manitowoc County Sheriff's Department employees, they had been pulled in directly to the civil lawsuit. They knew because the depositions were focused in Maine on their actions in prolonging the imprisonment of Stephen Avery beyond 1995 or 1996. They knew by virtue of the deposition that their personal reputation was at stake, that their personal actions were under scrutiny, and that regardless of insurance coverage and what insurer had what layer or whatever, there was a self-insured layer in there, or what the limits on top of the layer of policy of coverage were. Regardless of all that, do you think for a moment that Lieutenant Lenk or Sergeant Colborn wouldn't consider the fact that this personal ambitions for promotion or for retaining his rank, or perhaps political ambitions, And lo and behold, in the fall of 2006, Sergeant Colborn threw his hat in and ran for sheriff in this county. You think for a moment they didn't consider the possibility that their interests were affected by the actions of the department at issue in that lawsuit, and potentially their own personal actions being called into question, regardless of how defensible they may have thought of their own actions were? Of course not. It is information that bears on bias. Does it have an institutional aspects? Sure. It all has highly individual aspects to it. And so that's why I sort of abjure the adjectives in front of the word bias, in the sense that it's bias that we would be exploring. And yes, it is linked to an individual witness. We do not propose to come in and offer evidence in the abstract simply to establish that the department was biased and therefore every member of it was biased. This is perhaps subtle, but we may well, though, be entitled to explore an individual's identification with his department, identification with his reputation, sense of his own reputation being at stake, or his own actions being attacked, called into question. And it would not be conceivably out of the line here to recall for the court to recall that on the witness stand on July 5, 2006, the former sheriff of Manitowoc County revealed himself to be perhaps the last person in the world who's ever heard of Stephen Avery, who's not yet ready to accept the fact that Mr. Avery was innocent of the crime for which he was convicted, a rape which he was convicted of in 1985. Page 7 of the July 5, 2006 transcript, and it sticks out to me because I remember watching the court's reaction. The court, I'll recall the answer. Attorney Strang, and at my own time, would it be strange that a department headed by a man who held that attitude might be affected, that attitude in the hierarchy down the line? It would not. Doesn't mean we get to go on at, to our heart's content or forever without Sheriff Kenneth Peterson. I'm not suggesting that necessarily comes in at all, but I am suggesting that where we work and what we do and the things we commit our life to create in us biases that might be described in part as institutional biases, just as the United States Supreme Court has, and that these are among the sources of bias, and it's entirely appropriate for the defense to explore. In a criminal case, for the state to explore, if the defendant elects to offer a defense case in chief himself. The court, all right, let me ask somewhat of a follow-up to that. In terms of the defense offer to get the blood vial evidence and the argument that the defense would make, do I understand it to be that in considering what the defense feels is the bias of the witness and the opportunity to everything else, what's Lenk and Colborn are the subjects, if you will, of the defense claim? Attorney Strang, yes, and they may, yes, and we don't know that they necessarily would have acted directly. What we do know is that at the relevant time, James Lenk was not just a lieutenant, but as I understand it, the head of the Detective Bureau. So he's a person of brass and rank in the department. And Andrew Colborn, of course, was a sergeant, albeit the Road Patrol Division, if I recall, in November 2005. Do I know whether they directly acted or whether by virtue of familiarity and rank within the department that they may have known where to get a master key or been able to ask someone for a key to obtain one? I don't know that. But the answer remains, I think yes, that I believe it would be Mr. Lenk or Mr. Colborn to whom alternatively would have had to ascribe a plan or an exercise to plant blood. Now, by his presence, Detective Remaker was also found and Mr. Lenk and Lieutenant Lenk is Detective Remaker's superior. However, Detective Remaker was not deposed in the 1983 action in federal court. Although I have not read all the depositions, I am unaware of his conduct within respect to the 1985 conviction of Mr. Avery ever becoming an issue at all. It would surprise me if it had, because I think he joins the department even after the 1995 or 1996 telephone call from Brown County Law Enforcement Agency, that is the connection to Sergeant Colborn, a lieutenant linked to the civil action. So Remaker is there. He's present. He works for Lenk, but I'm not aware of any personal connection of Detective Remaker to the lawsuit that Mr. Avery brought against Manitowoc County. He has only the connection of working for the Manitowoc County Sheriff's Department under Lieutenant Lenk's supervision, insofar as I know. The court, who will be speaking for the state? Mr. Fallon? Attorney Fallon. Yes, I will be addressing the blood vial issue, and Mr. Krause will follow up with a bias discussion on behalf of the state. With respect to the blood vial evidence, I will begin there. The only thing that I will argue by the defense is the fact that we actually began in the same place with the Richardson case. After that, I agree with very little, if anything, represented by the defense. Richardson, it does need to be distinguished. I think it's important for the court to consider exactly what Richardson was about and what Richardson actually held. Mr. Richardson was charged with a sexual assault, 5 counts, and 1 count of false imprisonment. His theory was that his estranged wife was framing him. He based that on the fact that again, his estranged wife was framing him. He based it on the fact that she called his divorce attorney and said that he, being Richardson, had sex with a 14-year-old girl 2 days prior to the charged event. Richardson also alleged that the mother of the victim talked to his estranged wife the day of the assault, that his estranged wife gave the victim's mother the phone number of the divorce attorney. The victim's mom reported the assault to the attorney, and she initially had lied about making the call until she was impeached with phone records. These are the facts. The defendant is merging the theories of Richardson and frame-up evidence with the Denny case because of the nature in which the frame-up defense, the planting of evidence, because that is the frame. The planting of the evidence by the police necessarily implies that police were involved in the death, either directly or in a cover-up of the death of Teresa Halbach. There's no other reason, inference to be drawn. As a result, I think they have to comply with both Denny and Richardson. Teresa Halbach was last seen alive on October 31st. Presumably, she had Tuesday and Wednesday off, although I think she had an appointment on Wednesday. But the important fact is that she was not seen or heard from by any member of her family or anyone else on Tuesday and Wednesday, the 1st and the 2nd of November. She was reported missing on November 3rd, and a missing persons report investigation was commenced. At approximately 10:30 a.m. on Saturday, November 5th, her car was found by volunteer searchers on the Avery property, secreted with brush and debris in the corner of the salvage yard farthest away from the defendant's residence. The vehicle was locked. Now let's step back in time, the time about 11 years ago. The defense requires us to do that. 11 years ago this month, the defendant's blood was drawn as part of the post-conviction relief motion process. Blood was drawn at Fox Lake Institution. Marlene Kranitz, M. Kranitz, the name of the paperwork, drew the blood. It was sent out for analysis by LabCorp, analyzed, and eventually returned to the clerk's office, clerk of court's office, where, as far as anyone knows, it sits until June 19, 2002. On that day, the file is examined by former District Attorney E. James Fitzgerald and Wendy Paul of the Project Innocence and 2 or 3 others, presumably at the request or order of Judge Hazelwood, the original trial judge. The box was apparently resealed with nothing more than Scotch tape at the time. At the time that the blood was not sent with fingernail clippings and the one unknown pubic hair for analysis. It remained with the clerk of court. Moving forward in time, the defendant is exonerated and released after serving an additional 12 years in prison for a crime he did not commit. His case generates a significant interest in publicity. Many people come and look at the court file freely. As counsel noted the last time around, either in person or in call, the public has a right to examine the facts and circumstances. The public includes the media and anyone else who had interest in the case. It's within that background that we were asked to make two assumptions, and this is where I think the defense proffer of proof fails, and fails miserably. We are to assume that someone, presumably a member of the sheriff's department, gained access to the clerk of court's office at a time unknown. Even today, when the court asks the defense to narrow the time frame, they can't say for sure that if it was a 2-year window, a 26-month window from September 03 until the end of October 05, could be, although they think most likely between November 3rd, 4th, and 5th. But someone gained access to the clerk's office, as I said, at a time unknown, presumably after he was free. Could have been before, or was it after the lawsuit was filed, before this alleged bias was supposedly created? This motive, apparently a motive and a bias to kill an innocent 25-year-old photographer, just so they could get back at Mr. Avery for besmirching the reputation and integrity of the Manitowoc County Police Department. Presumably, we are asked to speculate that happened because the two bailiffs have a key from the sheriff's department. Perhaps the sheriff has one for emergency situations as well, but the assumption falls woefully short. The speculation, the conjecture, falls short of what's required for admissibility. There's also no evidence to suggest anywhere, known at this time, that a member of the sheriff's department, past or present, has ever touched or handled that vial of blood. Not one shred. Part 2. That someone planted some of the blood in Halbach's vehicle sometime between October 31st and November 5th, or if you like, between November 3rd and November 5th. Presumably, that someone is a sheriff's officer, because it would have been mighty difficult for a member of the public to wander into that property and somehow gain access to a locked vehicle under the cover of debris and brush and the like and manage to plant blood. The suspects, as we now have clearly revealed, are important and apparently Lieutenant James Lenk and Sergeant Andy Colborn. As suggested in the state's reply to their proffer, Sergeant Colborn did not even get to the property until 5:30 that evening on November 5th, although he certainly was on the Avery property on the 4th and 5th for the consent searches previously discussed in the motions. But think about this: for them to have planted the blood to frame the defendant, they would have had to have known that she was dead. How could they have known that? Stephen Avery could have told them. If that was the case, we wouldn't be here. Brennan Dassey could have told them. Well, that's true, but he didn't tell anybody anything of noteworthiness until March 1st. Perhaps there was an anonymous tip, but we're led to believe that if the blood was removed from the clerk's office on November 3rd or 4th, or look, presumably in the early morning of the 5th, that it somehow got from here, somehow got from here out to there, and then not only did it somehow get from here to there, but it somehow got inside the locked vehicle under guard. A fact from the hearing is known as the Detective Fassbender's testimony. He was responsible in his efforts to cover the vehicle. Later in that afternoon, the vehicle was finally removed by the crime lab personnel at 8:42 p.m. Crime lab personnel arrived at 4 p.m. and were attending back and forth. They didn't stay with the vehicle. I think the testimony was that they weren't constantly there. But the crime lab people, the field response unit, arrived around 4 and did a number of things. Chiefly among them was to take care of this vehicle. So presumably someone went out there and planted this blood. You will recall the testimony, I believe, and the information that's been provided, that the vehicle was not opened until the next day at the crime lab, where it was then processed in Madison, not in Manitowoc. So assuming that someone could have led to make two assumptions. Law enforcement found that vehicle on the 3rd or 4th and got into it then, or they got into it on the 5th. How did they do that? And if they got into it on the 3rd, or the 4th, or in the morning of the 5th, then it stands to reason that they would have had to have known that she was dead. Example, if that's the state's case, then is the other evidence planted as well, the cell phone, the Palm Pilot, the camera. Apparently, we are led to believe that Lieutenant Lenk planted the key. And just because Lieutenant Lenk was apparently on the property during the execution of the March search warrant, he must have planted the blood fragment too, fragment with the victim's DNA. Well, I can assure you there's only one way that could have happened. You don't have a bullet fragment with Teresa Halbach's DNA on it unless you killed her. The fact that this was suggested is nothing short of preposterous and outrageous. We're not a court of law. We're not dealing with pleadings regarding a man's defense and on a charge of murder. We'd be dealing with a claim of slander and libel. Teresa Halbach's remains were not recovered until November 8th, and were not sure. They knew, they had a pretty good idea they were human bones on November 8th, and it's probably a recent inference that it was Teresa Halbach. But the identification that it was Teresa Halbach was a couple of days after that. So it seems to me, if you're doing blame somebody for a crime, then you better damn well know a crime was committed. You can't frame somebody for a crime unless you know the crime was committed. And how do you know the crime was committed on the 3rd or 4th or 5th unless they did it, or unless they assisted in covering it up? Maybe they helped Brendan Dassey, but that necessarily by implication implies law enforcement's involvement in her death. And if that's the case, then Denny applies, because that's third-party liability. Somebody else did it. I want the evidence. Show me the evidence that Lenk and Colborn were responsible for the death of Teresa Halbach before you got here and have the nerve, the unmitigated gall to get up here and suggest that they were responsible for her death by implication. That's the distinction between Richardson and our case. Richardson's frame-up theory did not imply that the victim's mother committed the assault. It did not imply his estranged wife committed the assault. In fact, it doesn't imply that anyone necessarily committed the assault. You can make a case, although counsel alluded to some of the facts that I don't think were in the Supreme Court opinion, probably were in the appellate opinion or Court of Appeals opinion. But one reading of the defense that necessarily implied that the crime occurred at all, or implied to the contrary that someone else did it. And if that's the case, then the analysis in Richardson is still half a bubble off plumb, because they should have used Scheidel if she has all these injuries indicative of a sexual assault, and yet you don't know who did it. So then there was a merger of the frame-up and a Denny argument, or a Scheidel, in Richardson. I'm speculating because that wasn't discussed, so we can't go down that road. In this case, it's clear the inference that the Sheriff's Department in general, and now we know Lieutenant Lenk and Sergeant Colborn in particular, are involved. We are led to believe because of some misconceived, ill-gotten theory of bias. Mr. Kratz will address this further, but I have to mention it. Even though they were not the defendants in the lawsuit, they had no personal liability. They had nothing at stake. They weren't even responsible for the original conviction in the first place. They were deposed as witnesses, as I understand, because they failed to pass on some information after the fact regarding somebody else, presumably Mr. Allen, the actual perpetrator of the crime against Penny Bernstein. But they weren't responsible for his wrongful conviction. They had nothing to do with it. They weren't defendants in the action. You can't frame someone for murder unless you know the murder occurred. Let's think about it. I'm going to get in there, and we'll sprinkle some blood around. Have got to do this quick. Got to put some blood on the CDL. Put some on the ignition. We'll put a spot here, another spot there. We'll do 4 spots. I have to open the car. Depending on the location of where the blood is, hopefully nobody will see me, or well, maybe everyone did see me. So there you must be more involved. How else could you sprinkle the blood in those locations? And more importantly, unless they knew Teresa Halbach was dead, how did they know that's her blood in there? Seems to me you're taking an awful chance of planting blood there. If you don't know a crime has occurred, you don't know it's her blood. Not an unreasonable inference that it's her blood, but it's a pretty good risk to take. Obstruction of justice, that's felony behavior. Misconduct in office for a police officer, tampering with evidence, the list goes on and on. I'm not going to risk my career over that. I think not. By implication, this frame-up theory is entirely different than the frame-up theory posited in Richardson, and it necessarily implies a police involvement. Because how can you take the chance of planting someone unless you know the crime occurred? And now, how would they know the crime occurred unless they were conspirators? Under the analysis, Denny does apply. Under that analysis, Denny does apply. And there is no motive. There's no opportunity, and there's no connection for Remaker, Colborn, or Lenk, or any other member of the Manitowoc County Sheriff's Department in this crime. In the alternative, if you found that the state's argument is not compelling enough, that there's a merger of the frame-up theory with Denny theory, and you wish to analyze this strictly under 904.03 analysis under Richardson, then the state would submit that the evidence is inadmissible under the theory as well. The evidence has to be relevant, and as we have discussed the last time around, relevance has two facets. It is again in the second facet of relevance, the materiality component, where this falls short. It's not material. And by the way, when you are evaluating materiality of evidence, you have to look at the evidence as a whole, and this is where the defense, again, continues to misread and misinterpret the holding of Holmes versus South Carolina. You still consider all evidence. You still evaluate it in determining the materiality. You still have to evaluate it in the calculus of determining the probative value of whether the probative value is substantially outweighed by the prejudicial effect, waste of time, confusion, etc. The defense fails on part 2, the materiality component, the facet of demonstrating that there is a connection and that there's a word connection to the case at hand, a tendency to make a consequential fact more or less probable. On the third step of the Richardson analysis, the balancing, there is an unfair prejudice with respect to the existence of that vial of blood and its admissibility. Given the time frame involved here, the court's determination that preservative testing, EDTA testing, is not reliable enough, it certainly undermines the state's ability to reply, at least in a scientific mode, if not a practical mode, and I will get to that in a moment, as to the possibility that this blood found in the Clerk of Court's office, which we will still don't know how it would have gotten from here to the crime scene, other than by speculation or conjecture, was the same type of blood, was the source of blood at the scene. With respect to the inmate's statements, I'll rely on the comments in my brief, but I think they need to be reconsidered if this evidence is admitted, and reconsidered because their probative value is now increased as a retort, because it's evidence of bias and a motive and intent. It's evidence of this crime possessed by the defendant long before any supposed motive, bias, or evidence existed on behalf of Lieutenant Lenk, Sergeant Colborn, or any other member of the Manitowoc County Sheriff's Department. In terms of the practical considerations here, it seems to me that there would be a great deal of witnesses called, whether it's the groundskeeper, whether it's members of the Clerk of Court's office. Anybody ever seen Lieutenant Lenk in the Clerk of Court's office? When did you see him? How long ago was that? And I point out that there was no reason for any of that questioning, no reason for that investigative purpose until the existence of this vial of blood was revealed. There's no reason to test what was in the car for preservatives. There's no reason to test what was in her car for cellular degradation or any other type of test one may suggest until the vial of blood presented itself. And likewise, there was no reason to interview every member of the clerk's office or interview the bailiffs, where now were supposed to. I think the best example in this case, getting sidetracked and going down the road of confusion and unrelated issues, is their demand for disclosure of exculpatory information. It reads, for all the reasons stated in the state's brief, we're going to be looking at work schedules for Lieutenant Lenk, Sergeant Colborn, and I'm not sure if Detective Remaker has now been thrown into the mix or not. We're going to be looking at the disciplinary records that apparently they want us to track down. We're going to be looking at access, who had keys, what the codes were for the clerk of court's office. There's a key to get in the outside door, and there's a code to get behind. So, who got the codes? When they got the codes? Were the codes changed? Their disclosure form is an indictment of the folly of this argument and supports the state's theory that all we're going to do is down the wrong track. More confusion, more delay. We're going to be spending time chasing down this vial of blood. How can they have got into the clerk of court's office? Could they get in on the Thursday morning? Was it Friday, do you think? Or maybe it was really early Saturday, and then somebody got that blood out of there. Well, who had keys and how did they get in? It's still, their offer of proof fails, and it fails miserably because there's nothing other than conjecture or speculation as to who got into the clerk of court's office, whether the vial itself was taken and then later returned, or a portion of the vial was taken and returned. And just how did they do that? Did they use a needle and a syringe? Did they pop the top? Did they pop the cork, pour a little in their beaker, and secret themselves away? In other words, they burglarized the clerk of court, which, interestingly enough, is another act. That's a felony. If it's a law enforcement officer, you've got a burglary, you've evidence tampering, you've got misconduct in office, you've got obstructing of justice. I'm sure when we're done with this law school quiz, I could come up with a few more charges. Confusion delay will necessarily result by the admissibility of this evidence, and as a result, this evidence must and should be excluded. Thank you. Mr. Kratz will address bias. The court. Okay. Attorney Kratz, I did not know if you had any other questions on the issue of blood vial itself. I think Mr. Fallon made it clear that the state's position is that there is no linkage. There is no connection between the vial of blood and the blood that's in the SUV. I agree with much of what Mr. Strang was regarding bias, interestingly enough, in that it is not a collateral matter. It is something, when appropriately applied, that witnesses can be impeached with. As long as we're talking about cops, let me talk about bad cops, because that's what Mr. Strang and Mr. Buting are alleging here, Judge. Again, we're not talking about negligence or something along those lines. We're talking about criminal behavior. We're talking about malfeasance. And as my memorandum to the court suggested, that when bias is involved, like the blood vial evidence, that bias is also interrelated here. We're talking about criminal behavior of cops. There had better be some proof. There had better be something other than Mr. Buting standing up, because apparently he can, and saying, what Lieutenant Lenk planted the evidence, or Sergeant Colborn planted evidence. This is institutional bias, or at least some version of that Mr. Strang has attempted to apply to Lieutenant Lenk and Sergeant Colborn, at least, if their theory is so to be adopted, Judge. Shouldn't stop there. What then difference is there to Lieutenant Lenk was embarrassed by Mr. Avery's lawsuit? Why not Detective Remaker? Why not Deputy Jost? Why not members of the Clerk of Court's office, who may have been, as county employees, embarrassed? And so, what Williamson and other bias cases do, they don't allow that kind of questioning unless there's evidence that can be rationally related to the particular witness. I'm glad that Mr. Strang mentioned Sheriff Peterson, because by at least example, the differences between Sheriff Peterson and bias that may hold. If he was ever in fact going to be a witness in this case, may be appropriate to go into this wrongful conviction or the bias against Mr. Avery. But that doesn't apply to Lieutenant Lenk, doesn't apply to Sergeant Colborn, and there is no evidence that it does. Again, Lenk and Colborn were not involved in the 1985 prior conviction, not involved in the lawsuit. Mr. Strang suggests that they were somehow pulled into the lawsuit. The court already knows to what extent they're involved in the civil lawsuit, that is, giving a very short deposition. And so the embarrassment as a member of the Sheriff's Department when dealing with the professional reputations, when dealing with a slew of criminal misconduct, does not rise to the level of rationality related to a particular piece of evidence. If this court, however, is going to allow some kind of evidence about the 1985 wrongful conviction, I have given suggestions on the last page. There are facts that do not include the lawsuit. There are facts of the wrongful conviction itself that could be offered as bias, but certainly should apply then to Lieutenant Lenk and Sergeant Colborn and everybody else. And for that reason, the state believes that when the court looks at Williamson, when the court decides whether or not it's rationally related to any of the specific witnesses, although maybe not as impassioned as Mr. Fallon, just as strenuously judge, I'm asking the court to reject this kind of evidence. As they cannot, in fact, I think the defense may even agree that they cannot connect it directly to either of these two witnesses as compared to the universe of other potential witnesses from the Sheriff's Department, and shouldn't be allowed. That's all I've got, Judge. Attorney Fallon, Your Honor, I forgot to mention one other thing in response to the defense, and that is their right to present a defense. With respect to that, I think the court is familiar with South Carolina versus Holmes and the pleadings. I just wanted to make the court and counsel aware of a decision that was decided 2 days ago dealing with the right to present a defense. I have a copy for the court, Section 5 of the Muckerheide, Muckerheide case. Part 5 deals with the defense right to present a defense. And interestingly enough, there's a discussion of Shido and other acts evidence contained with it. So I would ask the court to review that as you consider one of counsel's opening points, the right to present a defense. Because, again, here's the latest, and the court acknowledging that that's not a limitless right, or that one must introduce relevant and material evidence. So, thank you. The court, thank you. Attorney Beauty, if I could just address the last point very briefly. I haven't thoroughly read the Muckerheide. I think it is the way you pronounce it. Muckerheide, okay, decision that Mr. Fallon is referring to. But I did briefly see it when it came down a couple of days ago. That's the one where the defense wanted to offer evidence from, I believe, the father that it was a homicide while intoxicated. The passenger was killed. Mr. Muckerheide was the driver. He argued that the passenger grabbed the wheel and forced him to crash. And it was affirmative, and it was the affirmative defense for the homicide while intoxicated. And he had evidence that the victim's father was going to say that the victim had also done that when he, the father, was driving, and so on and so forth. Well, very little of the case deals with the constitutional right to present a defense. What it does say when it gets to that point at the very end is it points out that Muckerheide was nevertheless allowed to present his entire defense and to make the argument that on that occasion the defendant did in fact grab the defendant's wheel. And the only evidence that they didn't hear was the minimally probative evidence that on a prior occasion with a different driver, under a different circumstances, the victim had gestured toward or grabbed the steering wheel. That's very different from what we have here, where a complete explanation for a very otherwise damning circumstantial evidence would be denied. Mr. Fallon just kept pounding away like there's no way this could be unless officers killed her. They couldn't have done this planning unless they were the ones that did the crime. They had to have killed her. He must have said that like 5 or 6 different times in their argument. And that's just plain wrong. It's just simply wrong. On November 5th, at approximately 2 p.m., which is around the same time, by the way, in their new statement of facts, or first statement, or vertment of facts, they say Lenk put himself on duty, arrived at the salvage yard. Meanwhile, Mr. Kratz and Wiegert and Remaker, and I believe also D.A. Rohrer, were all over at the same time at Judge Fox's home in Two Rivers, I believe, presenting an affidavit in which they swore under oath that they had believed they would find evidence of homicide if permitted to search every property. Now, we don't presume that sworn testimony was false, yet nevertheless, they were investigating this case as a homicide by the time Lenk supposedly even shows up at the scene as early as 2 p.m. It's not necessary to show murderous intent on the part of officers. We're showing opportunist intent. Mr. Fallon made a very nice, passionate closing argument here, which I'm not going to repeat or try to outdo at this point, except to say that fine, make that argument to the jury. He is fully entitled to do that. He's going to be required to do that because of the conduct, not because Mr. Kratz says Jerry Buting gets up here and just says it so. I'm not the one who put myself on duty at a homicide investigation when I knew that my boss had already recused the department, supposedly, from having leadership involvement. I'm not the one who volunteered to go search the primary, in fact, only suspect in the police's eyes, his very residence. I'm not the one who didn't tell Calumet people that I was subpoenaed and involved in the civil case. The reason they have to do all this is because their people put themselves in that position. And for whatever reason, if it's purely coincidence, then a jury should decide that. I don't think it is. I think there's more than sufficient. Remember, Richardson says tendency. Richardson doesn't even require the legitimate tendency to show this. It's any tendency. And clearly this evidence has any tendency to make a consequential fact less probable here. That is, the consequential fact who killed Teresa Halbach. As I said before, if somebody put the blood of Stephen Avery into that RAV4, then it's more probable that he is innocent of the crime that he's being charged with. He would impose an impossible burden. I don't know what he expects, that we're supposed to have present a videotape of the perpetrator sneaking to the clerk's office. Here's what key he uses. We zoom in, you can see, this is the key with the serial number, and so on, which must have taken from such and such, inserted into the door, and there he is. He's grabbing the vial, and here how he's taking it out of the vial, and here's where he goes. That's ridiculous. It's impossible that any court could expect that kind of certainty, and everything else is pure speculation. It's not speculation. There's a careful series of steps that we have laid out in our motion in great detail, showing our cards much more than they have. Mr. Fallon and Mr. Kratz, from a state's perspective, anything that doesn't go down the track towards conviction is a waste of time, and that is simply not the case. That's why we have juries, and that's why we have the adversary system in this country. And Mr. Avery is entitled, and indeed required, to present this defense of the blood vial evidence. This evidence as part of the defense that he is not guilty of this crime against Teresa Halbach. Thank you. The court. I know, Mr. Buting, that I asked you to do this, I think, earlier, but just so it's the last thing I hear before we conclude today, I want to make sure, as I'm sitting in my office this weekend, I have a clear representation of what the defense offer is. That is that, as I understand it, you can fill in the blanks and correct me when I'm wrong. Either Lenk or Colborn would have a sufficient basis to be biased in this case, or a motive for planting evidence, however you want to put it, because of the fact that they have a connection to the sheriff's department. They work for the sheriff's department. They were deposed in the civil case some 3 weeks earlier. And I'm trying to remember, is it one or both of them that received a telephone call or something in 1995? They put it in that file. Attorney Strain, they were both questioned about their own personal involvement in that particular incident. One thing I forgot to add is they were not the defendant's civil lawsuit yet. At the time, but that is not to say that they couldn't have been joined later as the discovery proceeded and the plaintiffs uncovered more wrongdoing or potential liability, because from that point forward, Mr. Avery sat another 8 years in prison. The court, okay, the theory being that they were given some information that they should have followed up on that might have led to his exoneration sooner. Attorney Beauty, yes, and the call involved, frankly, Mr. Allen, the ultimate. Attorney Strang, maybe you remember this past October. I will take a stab at it. I think the testimony from the two depositions was approximately this, that while he was working in the jail, Sergeant Colborn took a call from the law enforcement agency, the name of which he didn't remember at the time of the deposition. He thought it maybe was from Brown County. Realized that it wasn't a call that belonged in the jail, transferred the call to the Detective Bureau in the Sheriff's Department. And at that point, as I recall the deposition testimony, it breaks down into the Detective Lenk, who would have been in the Detective Bureau at that time, that doesn't remember whether he got the call or doesn't remember what it was about. There was and now I'm not remembering the deposition testimony well, but it's sort of, there's confusion there. And then both of them write a report about this phone call for the first time on September 12th, 2003, at Sheriff Peterson's request, which is the day after Avery has been released from prison. So they both write reports the day after. And at that point, they don't remember if it's 1995 or 1996 when the phone call came in. The gist of the phone call being from a law enforcement agency saying, we have someone here in custody who says that he did a rape for which someone else is in prison and it was in your county. The court, well, it sounds from what you're telling me, if it's the way it was presented, Colborn did what he should have done. He got the call to jail and referred it to the detective. Attorney Beauty, well, but that was challenged in the deposition and his failure to write any report. Attorney Strang, maybe the sensible thing to do is to just submit the depositions in there. Attorney Beauty, the point being, at what point this information was just coming out and they were being challenged on a memo that has not only their own reports, but also a memo that the investigator in the Manitowoc District Attorney's Office had written, which he had spoken to the two of them. It was inconsistent with what they had been testifying about, so it was their own involvement in that incident which was being challenged. The court, all right. At any rate, they have these depositions 3 weeks earlier. Sometime after the November 3rd, they, along with other members of the Manitowoc County Sheriff's Department, get the report about Teresa Halbach is missing, right? Attorney Beauty, actually, Sergeant Colborn, fortuitously or whatever, gets a call from Investigator Wiegert, I believe, learns that, or Dettering, one of the two, learns that one of the last places she has been, or one of the last places she has been that day she was last seen was the Avery residence, and says, okay, I will follow through. We'll get somebody out there to talk to him. Hangs up. And sometime shortly after that, Investigator Wiegert gets an unsolicited call from Lieutenant Lenk, which obviously means Colborn told Lenk. Lenk is, aha, Avery, let's go find out more about this. And then he then on his own, not being asked to, calls Wiegert and starts asking and showing increased interest from that point on, personal interest. The court. But that's on November 3rd. Attorney Beauty, yes. The court. Then the vehicle is discovered on the 5th. What was Officer Colborn on the scene on the Avery property on the 5th? Attorney Beauty, yes. The court. I know Lenk was, you said. Attorney Beauty. Lenk was. Colborn, I think the logs show him arriving around 5 p.m. Don't know if he was there earlier before the logs began or to be taken or not. Attorney Fallon. I can add, Jerry, we asked about when that log was started, and I think they started that log about 2:25 ballpark. So for what that's worth. Attorney Beauty. So it's about 3.5 hours after the vehicle was not discovered, but 3.5 hours after the police arrived. Attorney Fallon, right. Attorney Buting, again, the law enforcement people and the head prosecutors were gone from the scene by 2. No, between, I think, 1 and 3. Rower, Mr. Kratz, Wiggert, Remaker, they all left. The court. Does the defense have a theory as to how either Mr. Colborn or Mr. Lenk would have gotten into the vehicle to plant the blood? Attorney Buting. We have several theories. I don't know that. Again, where we have to show all of our cars, that we don't have to show anything. They don't have to show anything. The court. Well, here's the thing. Whatever the standard is, and I know the parties are arguing what it is, but certainly there is some burden that the defense has to meet. Attorney Buting, I understand. The court. And if that's the one you are asking, Attorney Strang, sure. The court. To give you a fair shake, I want to make sure I'm evaluating your request. Attorney Buting, okay. The court. With whatever showing you want to make. If you tell me we have no idea, I will accept that answer. I'm just trying to, what do you want the court to consider? Attorney Buting, well, the court can consider that we have what we have put in writing. And if you look at it carefully, you will see that there are some windows of opportunity in both terms of time and terms of physical opportunity. But by the way, the whole question of whether the vehicle was truly locked at the scene when first discovered is not as clear as the state would have you believe, because the volunteer who discovered it said she thought that they checked the doors, that they were locked. At the prelim, this is her testimony. However, she also thought that it was only a 2-door, not a 4-door. So that's inconsistent with her having checked all 4 doors, 5 doors actually, if you include the hatch. Even if it was, who do you go to lock yourself out of the car? Who do you call? The police. We also have the evidence that you have seen the report that from a locksmith that this particular RAV4 was very easily opened by these jimmies that the police officers have. Poses no difficulties. And as they have described in the written pleadings, the vehicle was covered actually with almost ideal situation where it was obscured from the view of the other officers by gigantic tarps, creating a tent over it, hiding it from the view of anybody, but obviously leaving access in and out at either end. So whether that's when it happened, that's another possibility. It was also getting dark by probably even before the crime lab arrived, because I believe sunset was at 4:30 and the crime lab didn't arrive until 4. The court, all right. I will definitely reread your memorandum again. Is there anything else you want to tell me this afternoon? Attorney Buting, I don't think so. I think that I think we have covered almost all the issues. Attorney Fallon, Your Honor, if you are going to do that, then I would ask the court to consider this one circumstantial or coincidental fact. If the blood was planted in the vehicle, then it must have been entirely fortuitous that Pam Stern happened upon that property of her own violation and by the grace of God found the car. Unless, of course, she was told to go there, unless she's a conspirator. Because if you're going to plant blood and then have it discovered, then how does that happen? Just coincidence? Who had the Jimmy? That's a question. And finally, I just asked the court to think back to Special Agent Fassbender's testimony at the motion hearing. He said that they attempted to put a tarp on it and attempted to do it to tent-like thing, but they were not successful because of the wind and the weather prevented that from happening. So again, I certainly would invite the court to check Pam Stern's testimony at the prelim and the motion hearing as you evaluate the proffer. Thanks. The court, all right. I realize there's another motion related to these and that it would come in with respect to wrongful conviction evidence. I have written proposals for the parties, or the written arguments with respect to this issue, and I think Mr. Kratz addressed it somewhat in his comments as well. Attorney Kratz, I did, Judge. The court, Is there anything else? Attorney Kratz. No, I rely on my brief comments today, but only in the standards, but the number of facts that the court will have to, decide what, if anything, is properly admitted for the impeachment purposes is laid out in my memo. That's all. The court. Anything further from the state? Attorney Kratz. The defense. The court. The defense. I'm sorry. Attorney Strain. We laid out a proffer, which is essentially everything we would like to offer on the wrongful conviction on the lawsuit. The state comes back saying none of it should come in, but alternatively, here is 4 things if you're going to let anything in, and the state omits entirely the lawsuit from its proposal. Will allow some very limited evidence as to the prior wrongful conviction. When you read the 4 things, someone coming fresh to this would be left with the impression that the state was on Stephen Avery's side in an effort to exonerate this poor wrongfully convicted man. Because, why? It was a state crime laboratory that tested the DNA for him and found that it was good, that it was not his. And it was the state of Wisconsin joined in securing defendant's release in 2003. My guess is the court comes down to somewhere in between 2 poles that the parties have offered. It's the general impression that the state's limited presentation is that it was somehow a joint effort to secure the release of a wrongfully convicted man for 18 years that it took, and decided that it was not as the docket sheet bears out. And again, what we offered was everything we would like to get in. I'm going to leave this one to the court. The issues of bias and impeachment and credibility are pretty well framed here, and I think the court can strike a pretty good balance. The court. Anything else? If not, we're adjourned for the day. Attorney Buting, do you think that we would know by Monday on any or some of these? The court. Depends on how far I can get this weekend. As soon as I've got something for you, I will let you know. I realize that this issue is important to both parties, so I'm going to take as long as I feel I need to make a decision. Attorney Strang, does the court anticipate a written ruling on these issues? The court, I don't know that either yet. Attorney Strang, very well. Attorney Fallon, I'm sorry, I did not hear that. Attorney Buting, I didn't hear. The court, I said I don't know that either yet. Oh, Attorney Buting, oh, okay. Proceedings concluded.